appreciate what these amendments represent, we have to go back and revisit the Civil War and the period immediately following the Civil War of Reconstruction. So the Civil War was clearly fought over the issue of slavery. The South wanted to preserve the institution of slavery and, in fact, extend it into other states and territories, while the Republican Party of Abraham Lincoln opposed the extension of slavery. And so when Lincoln was elected in 1860, Southern states seceded from the Union, and that is what led to the Civil War. The defeat of the South in April of 1865 was then followed by the period that is known as Reconstruction, the effort to bring the country back together again. By April of 1865, President Lincoln had been assassinated and Andrew Johnson became president. Now, Andrew Johnson and Congress had very different ideas about how to bring the country back together again. Johnson wanted to let those southern states that had seceded, he wanted to allow them to re-enter the Union with very little consequence. And so we can see here Andrew Johnson's plan for Reconstruction. This was known as presidential Reconstruction. So each Confederate state would be readmitted back into the Union as long as 10% of its residents swore allegiance to the Union, and as long as they ratified the 13th Amendment. Now, the Republican-dominated Congress insisted that Congress and not the president had the right to set the terms for readmitting, excuse me one second here, getting a phone call here, for readmitting states back into the Union. Now, while Congress was in recess, Johnson enacted his plan for Reconstruction. And because it was so lenient, it allowed Confederate leaders to resume control of southern states. And when Confederate leaders took control of southern states, they enacted a series of laws known as the Black Codes. The intent was to restrict the freedom of African Americans and to compel them to work as low-wage sharecroppers. And so according to these Black Codes, African Americans could not own property, they would have no voting rights, and if they were found to not be employed, they would be declared vagrants. They could then be arrested and sent out, contracted out to work for no pay, which was in essence slavery by another name. Now, as you can imagine, Congress was irate, and they responded by taking control of Reconstruction with the passage of the 13th, 14th, and 15th Amendments. The 13th, 14th, and 15th Amendments were intended to reverse these Black Codes and to create a true biracial democracy in the United States. So the 13th Amendment reads, "Neither slavery nor involuntary servitude, except as punishment for crime whereof the party shall have been duly convicted, shall exist within the United States or any place subject to their jurisdiction." Now, this was ratified in 1865, and it resulted from more than 200 years of failed compromise over slavery. Slavery had been legal in all 13 states when the Declaration of Independence was written in 1776. The Constitutional Convention, as we had seen, took slavery off the table because had slavery been abolished when the Constitution was written, Southern states at that time in 1787 would have seceded from the Union. In the 1857 Dred Scott case, the Supreme Court ruled that slaves were property and not citizens. And even if a slave was taken to a free state, that individual would still be considered a slave. And as a result, the government could not limit the spread of slavery into the territories. That was the result of the Dred Scott ruling. The Dred Scott ruling also said that blacks, whether free or slaves, could never be citizens, and that slave holders could bring their property anywhere. And that Dred Scott decision would be overturned by the 13th Amendment. Congress proposed the 13th Amendment in January of 1865, but it was not ratified by the states until December of 1865, 8 months after Lincoln's assassination. But in the era of Jim Crow, Southern states passed laws to re-enslave blacks. And so, according to the Black Codes, tens of thousands of African Americans were arbitrarily arrested. They were hit with outrageous fines and charged for the cost of their own arrests. And with no means to pay for these fines, prisoners were sold as forced laborers to coal mines, to lumber camps, and farm plantations. Thousands of other African Americans were simply seized by Southern landowners and compelled into involuntary servitude. Government officials leased falsely imprisoned blacks to small-town entrepreneurs, to corporations, including U.S. Steel, corporations that look for cheap and abundant labor. And so armies of Black men labored without compensation. They were forced through beatings and physical torture to do the biddings of the white masters, even after the official abolition of slavery. And so, as I mentioned, this amounted to slavery by another name, which was the title of a book by Douglas Blackman. And what it refers to is this practice of arresting blacks in the South because they had no jobs, because they were unemployed. And so they were arrested for vagrancy, and they were then forced to work for on either plantations or for corporations, forced to work with no financial return. Now, this all happened after the passage of the 13th Amendment. And that is why the subtitle of this book is The Re-Enslavement of Black Americans from the Civil War to World War II. Now, the question of reparations for slavery has been raised in recent years. Some Americans believe that this nation owes a financial and moral debt to African Americans, just as the heirs to the survivors of Japanese American internment camps were compensated. And they argue that the negative effects of slavery can be seen today in high rates of poverty and incarceration in the Black community. And therefore, Blacks today are still feeling the effects of slavery, and they deserve reparations. But others argue that there are no survivors of slavery alive today. And that those blacks today have little connection with slaves, and therefore they should not be entitled to reparations, and that there are many who came to the United States after the end of slavery, um, many white citizens, and therefore they should not have to pay taxes that would go for reparations for the sin of slavery when they and their ancestors were not in this country when there was slavery. Well, I think that debate is going to continue. There's a third possibility that argues that the United States should pay reparations for the sin of slavery, but that the reparations should not go to individual African Americans today, but rather to programs to help the African American community. Programs such as preschool education, better housing in inner cities, things like that. Well, so the 13th Amendment, which was adopted in December of 1865, formally ended slavery, but as we have seen, in some ways, slavery did continue in other forms of forced labor for blacks who were imprisoned after the passage of the 13th Amendment. Now, let us move to the 14th Amendment. Most Americans have no idea what the 14th Amendment is or how it affects their lives. Yet for more than a century, the 14th Amendment has been the legal basis for many major Supreme Court decisions. Some constitutional experts argue that the 14th Amendment is the most important of all amendments. So let us take a close look at this amendment. It contains 3 clauses that are basic to our civil liberties. It contains a citizenship clause, the due process clause, and the equal protection clause. In fact, many legal scholars believe that the 14th Amendment is so momentous that it actually represented a new constitution. So to unwrap and dissect this consequential amendment, we have to look once again at the historical context. As mentioned, in the immediate wake of the Civil War, former Confederates enacted the Black Codes, which regulated every aspect of life of former slaves. Former slaves were not permitted to vote, to own firearms, to travel. And then Congress passed the 14th Amendment in order to reverse the Black Codes and to grant rights of citizenship to African Americans. The Republican-dominated Congress said that Southern states would not be readmitted back into the Union unless they ratified the 13th and 14th Amendment. So the 14th Amendment begins by saying all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. This is a clear repudiation of the notorious Dred Scott decision of 1857, which asserted that a Black man, even if he or she was born free, could not claim rights of citizenship under the Constitution. But the 14th Amendment reverses that by claiming that anyone born in the United States would therefore be accorded citizenship. Now, the amendment applied to those persons subject to the jurisdiction of the United States. Now, why was this included? Because it was included so that American Indians would not be given citizenship, because Native Americans living on reservations were not subject to the jurisdiction of the United States, and therefore were not granted citizenship by the 14th Amendment. Native Americans did not become citizens of the United States until 1924. Now, this section of the 14th Amendment has generated considerable controversy over the issue surrounding anchor babies. The term anchor babies is a derogatory reference to the practice of non-citizen mothers who come to the United States solely for the purpose of giving birth so that their child has automatic American citizenship. It's also called birthright citizenship. And that might then help the mother and other family members get legal residence in the United States. Now, birthright citizenship has also become an issue in the debate surrounding immigration. Children of undocumented aliens who are born here, even though their parents are undocumented, are automatically citizens of the United States under the 14th Amendment, which once again states that anyone born in the United States becomes citizens. Now, in 2018, Trump said he intended to issue an executive order ending birthright citizenship. And so here is a cartoon where a Trump supporter says Trump wants to eliminate birthright citizenship and deport them all. And here's a Native American who says, sure gonna miss you because we are all immigrants to the United States other than Native Americans. But Trump decided not to issue that executive order relinquishing birthright citizenship when he was told that the Supreme Court would certainly rule against him because it would violate the 14th Amendment. Now let us look at another section of the 14th Amendment that states, no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. Now, this section of the 14th Amendment greatly expanded the civil and legal rights of all Americans by protecting them from infringement by the states. Now, when the Bill of Rights was issued in 1791, those first 10 amendments addressed rights that the federal government could not take away. However, state governments could take away many of those rights. And so this part of the 14th Amendment applies the Bill of Rights not only in federal cases, but it applies them to the states as well. It prevents states from infringing on the civil and legal rights of all Americans. Nevertheless, the question of what rights are covered under privileges and immunities in this section remains unclear. But eventually, the Supreme Court did apply most of the provisions in the Bill of Rights to the states, so that now, today, states may not deprive any citizen of their rights that are part of the first 10 amendments. Now, the 14th Amendment also says, nor shall any state deprive any person of life, liberty, or property without due process of law. This is the due process part of the 14th Amendment. Now, the term due process was part of the Fifth Amendment. The due process clause of the Fifth Amendment applied only to the federal government It said that the federal government may not deny citizens of due process. But here, the 14th Amendment is saying that no state shall deprive anyone without due process of laws. Among the liberties that states may not deprive, according to the Roe v. Wade decision, is a woman's right to decide whether or not to terminate her pregnancy. So the Roe v. Wade decision was based heavily on the 14th Amendment, that no state can deprive a person of life, liberty, or property without due process of law. Now, the court in the Roe v. Wade decision maintained that the fetus was not a person under the 14th Amendment. Therefore, the threshold for legal rights under the 14th Amendment has traditionally been held that a person becomes a person at birth. The Supreme Court has ruled that another liberty under the 14th Amendment is a person's right to refuse medical treatment. But the court ruled that the right to commit suicide is not protected under the Due Process Clause. Therefore, upholding state laws prohibiting physician-assisted suicide, these laws have been upheld by the Supreme Court. Now, the 14th Amendment also says that no state may deny any person within its jurisdiction the equal protection of the laws. This equal protection clause contains the first use in the Constitution of the word equal. Now think about that. The word equal never appeared in the Constitution until the 14th Amendment. And it was used in regards to the rights of individuals. And it was clearly intended to stop state governments from discriminating against Black Americans. And over the years, it would play a key role in many landmark civil rights cases. The Equal Protection Clause prohibits unreasonable discrimination. Now, racial segregation continued throughout the period of Jim Crow. In 1896, the Supreme Court ruled that segregation was constitutional under the separate but equal ruling in the case of Plessy versus Ferguson. But that ruling was overturned in Brown versus Board of Ed, 1954, when the court ruled that separate was inherently unequal, and therefore segregation violated the Equal Protection Clause of the 14th Amendment. This clause was also instrumental in the passage of the 1964 Civil Rights Act, as well as the Voting Rights Act of 1965. And the Equal Protection Clause was also crucial in striking down laws that discriminated against women and gays as well. The sweeping provisions of the 14th Amendment effectively altered the balance of power between federal governments and state governments in the United States. And it gave the federal government much more power by preventing states from depriving its citizens of civil liberties. In the latest section of the 14th Amendment, it authorizes the federal government to punish states that violate their citizens' right to vote. So if a state prevented any of its citizens the right to vote, the 14th Amendment gave Congress the right to reduce that state's representation in Congress. And it mandated that anyone engaged in insurrection against the United States could not hold civil, military, or elected office. Now, why was this included in the 14th Amendment? Because they didn't want former Confederate leaders to hold elected office after the Civil War. So the 14th Amendment once again said that anyone who engaged in insurrection against the United States, meaning the Civil War, could not hold civil, military, or elected office. Now, that provision in the 14th Amendment could possibly be invoked against former President Trump to prevent him from ever running for office in the future. There are two ways that Trump could be prevented from running for office in the future. If he is convicted in the impeachment trial, then Congress, actually it's the Senate, could vote to prevent him from ever holding office again. And that would just be a majority vote. So if he is convicted, and if more than 50 senators vote to prevent Trump from ever holding office again, then he would not be eligible to run for office. That's one way. But conviction in the Senate seems very unlikely, particularly since 45 Republicans claim that the entire trial is unconstitutional. So Democrats are looking for other ways to prevent Trump from ever running for office. And so they have cited this provision of the 14th Amendment that mandates that anyone who engages in insurrection against the United States cannot hold elected office. And so they are trying to prove that Trump engaged in insurrection, in inciting the mob that eventually attacked the Capitol. So this is a very contemporary relevance of the 14th Amendment to what is going on today. Now let us go to the 15th Amendment. The 15th Amendment guarantees all male citizens, male adult citizens, the right to vote. Now, this, of course, was passed to guarantee Blacks the right to vote. Now, some people argued that at the time that women should be included. But that amendment, the 15th Amendment, which was ratified in 1870, failed to include women. But as it turned out, even after ratification, this 15th Amendment really offered very little protection for African Americans voting in the South. Southern states sought to subvert the 15th Amendment through a number of devices, such as the grandfather clause. So some Southern states stipulated that you were not allowed to vote unless your grandfather was eligible to vote. Well, for Blacks in the South in the 1870s and 1880s and 1890s, clearly their grandfathers were not eligible to vote. So that was one way that Blacks were prevented from voting. Another device was the literacy test. Well, under slavery, it was a crime for slaves to get an education. And so once slavery ended, very few slaves were literate. And so literacy tests would prevent slaves from, or former slaves from voting. Also, these tests were applied unequally. So the literacy test for a white Southerner was much easier than for a Black who was hoping to vote. And a third device to get around the 15th Amendment was the poll tax. Now, all of these devices effectively kept Blacks away from the voting booth. But the civil rights movement of the 1950s and 1960s attempted to register African Americans to vote. And the Voting Rights Act of 1965 specifically prohibited literacy tests and the grandfather clause. it allowed federal officials to supervise voter registration. And Section 5 of the Voting Rights Act of 1965 prohibited certain states and districts that had discriminated against Blacks from implementing any change affecting voting without prior approval from the federal government. So states like Mississippi and Alabama that had previously deprived Blacks from the right to vote, if they wanted to change any laws affecting voting, they must first get approval from Congress. But in 2013, the conservative majority in Congress eviscerated this part of the Voting Rights Act. And in Shelby County versus Holder, in a 5-4 decision, the Supreme Court ruled that those states that came under Section 5 would no longer have to get federal approval to change their voting laws. Writing for the majority, Chief Justice John Roberts said, well, those states are no longer preventing Blacks from voting, therefore they should no longer be held to Section 5 prohibitions. And as a result of the Shelby decision, many of those states almost immediately instituted voter identification laws, which reduced the turnout of Black voters, because there were many Blacks who did not have driver license IDs or did not have whatever identification the states demanded. So, for example, some states refused to accept identification from a driver's license, but would accept an NRA ID card, the National Rifle Association. And that prevented many Blacks from voting. And those states also imposed restrictions on early voting and other measures which critics charged were aimed at voter suppression. Now, with Democrats back in control of both houses of Congress, there may be an effort to pass a new Voting Rights Act that would hopefully prevent voter suppression in the future. But that would depend on Democrats getting rid of the filibuster, because Republicans would most certainly vote against a new Voting Rights Act that would expand the electorate, because Republicans are convinced that the more people that vote, the less chance there is of Republicans winning elections. Okay, so that covers the 13th, 14th, and 15th Amendments, also known as the Civil War Amendments. Now, the period in American history from the 1890s to 1920 is called the Progressive Era. That is a time when the federal government adopted a series of reforms to counteract the negative effects of industrialization. In the last quarter of the 19th century, America was rapidly industrializing, and working conditions were horrific in those early days of the Industrial Revolution. Women and children worked 12, 14, 16 hours a day in unsafe and unventilated factories. And so the Progressive Era was a time when Congress adopted laws to eliminate unfair business practices, to improve working conditions. And so amendments 16 to 19 were adopted in order to create a more democratic and equitable society. The 16th Amendment, ratified in 1913, allowed Congress the right to levy an income tax. And the income tax was a progressive tax that required wealthier people to pay a higher percentage than less well-to-do Americans. And the 17th Amendment, also ratified in 1913, changed the way senators were elected. Article 1, Section 3 of the Constitution called for the election of senators by state legislators. And so, until the 17th Amendment, senators were not elected by the people. Rather, they were elected by state legislatures. But the 17th Amendment mandated direct election of senators by the people of the particular states. It also allowed states to determine the qualifications of voters who would elect senators. And so, interestingly, while women could not vote in presidential elections, because presidential elections are federal elections, some states allowed women to vote before women got the right to vote in federal elections. And several Western states, like Wyoming, allowed women to vote for US senators. And the reason for that is that Western states wanted to attract women to migrate to the Western states because so many of the people in the Western states were men, because they were pioneers who went out to the West. But there was an overwhelming number of men, and so to attract women, states advertised that women would be allowed to vote in state elections. The 17th Amendment also provides for the governor of a state to make a temporary appointment for senator if the office became vacant. And so when Kamala Harris, senator from California, became vice president, that gave the governor of California the right to name her replacement. Now, the 18th Amendment, ratified in 1919, prohibited the manufacture, sale, or transportation of intoxicating liquors to the United States. Manufacture, sale, or transportation. To enforce this amendment, Congress passed the Volstead Act, which banned the consumption of beer, wine, and distilled liquor. But almost immediately, an illegal bootlegging industry sprang up, and organized crime flourished as politicians and prohibition agents were on the take. And crime, like the St. Valentine's Day Massacre, where different gangs fought against each other for the right to bring in illegal alcohol. And so this noble experiment, as it was called, clearly failed. It was estimated that there was much higher consumption of alcohol during Prohibition than before the 18th Amendment was passed. And so by 1933, the 18th Amendment was repealed by the 21st Amendment. Now, the 19th Amendment, which was ratified in 1920, gave women the right to vote. Now, after independence in 1776, women were allowed to vote in New Jersey. But then in 1807, New Jersey revoked women's right to vote. In 1890, Wyoming became the first state to grant women the right to vote. And by 1919, 30 states had extended suffrage to women to vote in state elections. Now, the 19th Amendment allowed women to vote in state and federal elections. After the 19th Amendment was proposed, 3/4 of the states had to approve it, and Tennessee became the crucial state that met the 3/4 threshold in adopting the amendment. Now, the 19th Amendment was approved by just one vote, by Tennessee signing on. And that happened after a mother lobbied her son, who was serving in the state legislature, to support the amendment. And so the Tennessee state legislature supported the 19th Amendment by just one vote. Now, the 20th Amendment is known as the lame duck amendment. Originally, the Constitution created a 4-month period between the election of a president and the inauguration of the president. And so the president would be elected in November, and take office in March, 4 months. And that was also true for Congress. But that meant that the outgoing Congress had 4 months to do whatever it wanted without being accountable to voters, since they were going to be leaving anyway. And that is why it was called the lame duck Congress. And the newly elected Congress would not hold its first official session until the following December. In other words, 13 months after it had been elected. So that was very problematic. And so to correct this, the 20th Amendment changes the dates of when Congress and President actually take office. And so according to the 20th Amendment, the President and Vice President take office on January 20th at noon. And we saw that happening just a little more than a week ago. Senators take office on January 3rd. And so that narrows this lame duck period. Section 3 of the 20th Amendment addresses the issue of presidential succession if the president-elect were to die before assuming the presidency. Coincidentally, only 3 weeks after the ratification of this amendment, an assassin shot at President-elect Franklin D. Roosevelt in Miami. Roosevelt was not harmed by the assassination attempt, but the mayor of Chicago, who was in the entourage, was killed. Now, Section 3 of the 20th Amendment allows Congress to designate an acting president in the event that the president-elect or vice president-elect were not available by Inauguration Day. Now, that has never had to be invoked. In the Presidential Succession Act of 1947, Congress specified the order of succession after the vice president. And so after the vice president, as you can see on this chart, it would be the Speaker of the House, then the President pro tempore of the Senate. And so in today's Congress, if we hope it would not happen, but if the presidency and vice presidency became vacant, then Nancy Pelosi would be next in line. And after that, the President pro tempore of the Senate, who is Senator Leahy of Vermont. And after that, as you can see, the cabinet members, beginning with the Secretary of State. And then other cabinet members. And the reason for the order of these cabinet members that you see there is it was decided that it would be according to the date when those cabinet departments were created. And so the Secretary of Homeland Security was the last of these cabinet departments to be created. Now, the 21st Amendment, ratified in December of 1933, as I mentioned, repealed the 18th Amendment that mandated prohibition. Now, every amendment up to this point had been ratified by state legislators. The 21st Amendment was the first and only amendment to be ratified not by state legislatures, but by state conventions. And that was because opponents of prohibition realized that rural interests controlled most of the state legislatures. and rural interests supported prohibition. Thus, those who wanted to end prohibition advocated ratification through state conventions rather than state legislatures. The 22nd Amendment, ratified in 1951, limited the number of terms that a president could serve. Now, George Washington, our first president, established the tradition that a president would seek office only for the first 2 terms. Washington decided not to run for a 3rd term, and every president since Washington refused to run for a 3rd term until 1940, when FDR broke that precedent by running for a 3rd term. FDR served a 3rd term and then ran a 4th term. And he won that 4th term, but died just several months into his 4th term. And so the 22nd Amendment prevents any person from being elected president for more than a 2 consecutive term. And if serving, which means that a president could possibly serve for as many as 10 years in office. Why 10 years? Because let us say a vice president serves under a president who dies with less than 2 years left in that president's office. Well, that vice president would then become president, but he would not be elected president. And so he would serve out 2 years of the deceased president's term, but would still be eligible to run for 2 terms, which means 8 more years. So the maximum term that any president could serve is 10 years in these circumstances. Now, the 22nd Amendment created a lame duck president, that is, a president who is serving his 2nd term is a lame duck because he cannot serve beyond that. And because of that, presidents who serve out their 2nd term in office tend to lose influence because they will have no political power after the end of their 2nd term. The 23rd Amendment, which was ratified in 1961, provides electoral votes for the District of Columbia. It granted Washington, D.C., 3 electoral votes in presidential elections. Now, people living in Washington, D.C. are citizens of the United States. But up until the 23rd Amendment, they had no influence in presidential election because Washington, D.C. did not have any electoral votes. And so the 23rd Amendment corrects that by giving Washington, D.C. 3 electoral votes, which means that voters in Washington, D.C. will have a voice in deciding who will be president. Now, on the other hand, while residents of Washington, D.C. are citizens and they do pay federal income taxes, they have no representation in Congress. And so there is a move afoot today to make Washington, D.C. a state. Now, the Democratic Congress might have that ability to do that by a simple majority. Republicans will certainly oppose that because they are convinced that the vote in Washington, D.C. will be largely Democratic. Washington, D.C. has a large African-American population. And so that will add 3 votes to the Democratic column. The argument in favor of giving Washington, D.C. statehood is that Washington, D.C. has more people in it than 5 or 6 Western states in the United States. So why should Wyoming have 2 senators and a representative when it has barely a fraction of the population of Washington, D.C.? The 24th Amendment that was ratified in 1964 prohibited the use of poll tax in federal elections. So I mentioned before how Southern state governments use the poll tax to keep poor whites and blacks from casting their ballots. Now, even though the poll tax was prohibited by the 24th Amendment, it was still used in state elections until 1966. Then a Supreme Court ruling in 1966 maintained that poll taxes in state and local elections violated the Equal Protection Clause of the 14th Amendment and was therefore unconstitutional. So that seemed to eliminate the poll tax. However, in 2018, voters in Florida voted to restore voting rights to convicted felons. But last year, the state of Florida ruled that those convicted felons would first have to pay outstanding fines in order to be eligible to vote. Now, critics argued that to make felons pay for the right to vote actually constitutes a type of poll tax. Now, that will, I think, go up to the Supreme Court. So we'll see how the Supreme Court rules on whether convicted felons can be made to pay for fines in order to gain the right to vote. The 25th Amendment, ratified in 1967, is known as the Presidential Succession and Disability Amendment. And it has been in the news recently, as you know. So how did this amendment come about? Well, when President Kennedy was assassinated in 1963, that brought up the long-standing question about presidential succession. When the president died, does that mean that the vice president automatically becomes president? Or does it mean that he serves only as acting president? Another question that was unresolved at the time of the Kennedy assassination is, what happens when the vice presidency is vacant? And who determined when the president was disabled or incapable of carrying out official duties? Now, the vice presidency has been vacant 17 times before the 25th Amendment was ratified. 7 vice presidents died in office. So you can see the list here. And so when these 7 vice presidents died in office, the vice presidency was vacant. 2 vice presidents resigned. And 8 presidents died in office, which meant that the vice president was elevated. So 17 times before the 25th Amendment, the vice presidency had been vacant. Now, no president has ever died while the vice presidency was vacant. Now, Congress became concerned about all of this when Lyndon Johnson took office as a result of the assassination of President Kennedy. Now, Lyndon Johnson already had suffered 2 heart attacks when he became president in 1963. And when he became president, there was no vice president. And so Congress decided that something should be done about this. The 25th Amendment was implemented for the first time in 1973, when then Vice President Spiro Agnew resigned, and President Nixon was able to nominate Gerald Ford as Agnew's replacement. And so this was the first time that the vice presidency, when it became vacant, that vacancy was filled as a result of the 25th Amendment. And then in August of 1974, we all remember that Nixon resigned and Ford became president, and then Ford nominated Nelson Rockefeller as vice president. And so for the first time in American history, neither the presidency nor the vice presidency had been chosen by the voters. Gerald Ford had been elected vice president, but he became president. Nelson Rockefeller was never elected to the vice presidency. So we had a president and vice president, neither of whom were elected to those offices. Now, the 25th Amendment has three sections, actually four sections. The first section, as you can see, that in case of the removal of the president or his death or resignation, the vice president becomes president. And when there is a vacancy in the vice presidency, the president shall nominate the vice president. And section 3, the president may voluntarily turn over the reins of power when suffering from a temporary disability. Now, under section 3, this has been invoked only twice since the 25th Amendment was ratified. In 2002, when President George W. Bush was told that he would be getting anesthesia for a colonoscopy, he formally gave power to his vice president, Dick Cheney, using the rules set out by the 25th Amendment. But after about 2 hours, Bush was awake and he took back the presidency. In a second instance, in 2007, President Bush again invoked Section 3 so he could have another colonoscopy. And again, Cheney was acting president for about 2 hours until Bush was ready to take back the presidency. Now, when President Reagan was shot in 1981, he needed immediate surgery, so he could not invoke Section 3 because Section 3 is invoked by the president. And of course, Reagan was in no shape to invoke that section after he was shot. Now, Section 4 allows the vice president and a majority of the cabinet officers to declare that the president is disabled, so that the vice president can assume the president's official duties under the Disability Act. So this is what Democrats had hoped would happen earlier in January. They hoped that Vice President Pence and a majority of the cabinet officers would declare Trump unable to conduct the duties of the presidency, and that would remove Trump from the presidency. But Pence refused to invoke Section 4. Now, Section 4 also allows the president to contest that decision. So even if Pence and cabinet officers maintained that Trump was disabled and therefore should be removed from office, Trump would have undoubtedly contested that decision. And according to the 25th Amendment, Congress would then have to decide by a 2/3 vote whether the claim that the president is disabled is valid or not. Now, when Reagan was shot in 1981, his vice president, George H.W. Bush, did not invoke Section 4 because he was on an airplane returning from Texas when Reagan was shot. Now, you may remember that Secretary of State Al Haig then declared that he was in charge, but he wasn't. He was mistaken in believing that he was next in line in succession after the vice president. But it was the Speaker of the House and then the President pro tempore of the Senate who were ahead of Al Haig, who was Secretary of State at the time. Now, Section 4 of the 25th Amendment has never been invoked, but there were at least 2 occasions when the use of Section 4 was considered. In 1987, President Reagan's chief of staff, Howard Baker, was told by Reagan's advisors that the president was inattentive, that he was inept, and that Baker should be prepared to invoke the 25th Amendment to take away the duties of Reagan, but Baker refused to act on that advice. And most recently, on January 6th, excuse me one second, on January 6th of this year, Speaker Nancy Pelosi and Senate Minority Leader Chuck Schumer urged Pence to remove power from the president for his role in inciting the insurrection attempt. Those are the only times when the Section 4 of the 25th Amendment was even considered. Now, the 26th Amendment, which was ratified in 1971, was directly related to the Vietnam War. As the casualty rates of American soldiers escalated, many people wondered, why was it okay for 18-year-olds to die for their country but not have the right to vote? And so the 26th Amendment lowered the voting age from 21 to 18. It was the fastest amendment ever to be ratified. And the 27th and last amendment was ratified in 1992. It prevents members of Congress from voting themselves a pay raise before voters have a chance to kick them out of office for doing so. So the amendment prevents pay increases from taking effect until the start of the next term of office for representatives. This was actually proposed in 1789, along with 11 other proposed amendments. But 10 of those amendments were ratified, and they became the Bill of Rights. So this 27th Amendment allows voters the chance to punish senators and representatives for voting themselves a pay increase. Now, throughout American history, more than 11,000 amendments have been introduced into Congress. Yet the Constitution has been changed by amendment only 17 times since 1791. The Bill of Rights, the first 10 amendments, were part of the Constitution. So after the Bill of Rights, only 17 additional amendments have been added. In the more than 200 years since the Constitution was created, America has stretched across an entire continent, almost tripling in size when the Constitution was written. And the population and economy of this country has expanded more than the framers of the Constitution could ever have envisioned. Yet through all these changes, the Constitution has endured and adapted. Now, the framers knew it wasn't a perfect document, and there is considerable criticism about the Electoral College, about giving Wyoming 2 electoral votes and none to Washington, D.C., about the failure to include equal rights provisions for women, about how less populous states have undue influence in the electoral vote. So there are certainly imperfections in the Constitution. But as Benjamin Franklin said on the closing day of the Constitutional Convention in 1787, I agree to this Constitution with all its faults, if they are such, because I think a central government is necessary for us. I doubt, too, whether any other convention we can obtain may be able to make a better Constitution. And so that will be the final word on these series of lectures on the Constitution, the Bill of Rights, and other amendments. So at this point, we will stop